I'm opening the subcommittee work session number 2 from Children and Family Court, looking at the subject of recommendations for the family court. For the record, the last 2 years, there had been a special committee on the family division of the Circuit Court of the state of New Hampshire. It took me 9 months to learn how to say all of that. And we made numbers of recommendations, and most importantly, our work was done collaboratively. I've read some of the reports and documents in the past where family court has been accused of all kinds of different things. Whether justly or unjustly, it set up an adversarial relationship. And while that may be most court cases, that is not how we make progress when two branches of the government are trying to make progress. We gang up against problems, not against each other. The Speaker of the House turned down my request for the special committee to have 2 more years, but instead suggested I pull together a subcommittee of children and family law and pick the ones I wanted to be on it. My criteria for that were, number 1, the individual is a hard worker. Number 2 is bright, can really think complex things through. And thirdly, is a collaborative worker within the committee and as part of the committee with the judiciary. And so I have 7 brave and intrepid people on this, each of whom, at least so far, is very excited about it and I trust will continue to be. The chair appoints Representative Nelson to be the clerk. She didn't want to be this time. She is the clerk of the full committee, but I took a poll of all the members except for Representative Nelson here today, and you have been elected. So just write something. Here is the subcommittee work session sheet.
Thank you.
There's very little that needs to be done because I doubt we will ever vote here. And if we do, it won't be for quite some time. And perhaps when they revise it, they can list only the subcommittee members, which I have noted. Last week, we heard compelling testimony from Judge Michael Mace, giving us a good history of family court. And his report, or the outlines of his notes, we will eventually get to everyone. He lists various documents that he thinks would be helpful. I've gone over this with Attorney Kristen Grant, who is our legislative researcher, to find what might be good places to start. I want to go into some depth in terms of origin stories because it's good to know what the purposes were when this was started, what some of the problems they identified and sought to solve by standing up a separate family division, and then into the first year or so of the immediate look back to see how well they were doing. One of the reports that I found to be very, very helpful is the January 15th, 1995 report, co-chaired by Richard Gagliuso and Elizabeth Hager. And we have copies of that here that will be eventually distributed to everybody. I sat on my back deck yesterday afternoon and plowed through it. And what I discovered, not particularly to my amazement, is that that report very much mirrored the final report of our subcommittee that was turned in some time ago. The same issues were identified, the same problems in getting things done were identified, and so on. And this says to me two things. Number one, it says the same unhappy complainants are still around. We heard 12 hours of public testimony during the special committee, 12 hours from the public. And in many cases, they wanted us to relitigate their case, which of course we would not do and may not do. Additionally, it became clear as they were testifying, I think they got off easy. I would have imprisoned most of them. It was very clearly the one at fault was not the opposite litigant. It was not the judge or the judicial system. It was the person testifying. They were found guilty, or their pleas were not upheld because they shouldn't have been. There were cases, however, where people being pro se litigants were flying somewhat blind, and we are hoping to be able to have an introductory booklet written in non-technical language for pro se litigants. I realize there's some stuff around. I would agree with some of the earlier reports 20 years ago, 30 years ago. There isn't enough. There needs to be more. People do not understand, in spite of it being explained once and quickly, why certain rules of evidence should not be admitted, why some could be or should be, etc. We found that there may be, in addition to complainants without a cause, certain procedures that perhaps could be done differently. If this seems to be a constant thread through the reports, maybe there's something to it. As a member of NCSL and one holding a fellowship in children and family issues through that body, I have researchers who have been working on coming up with what other states do. Some states do not have an equivalent of family court. Many states do, and they differ significantly from each other. What do other states find to be helpful, especially in those areas where we seem to be butting our heads up against something? No group is perfect. They're not, neither are we, but we can learn from them and maybe share some of the things we do very well. We looked at the possibility of three different kinds of topics that we would address. One would be simply the court hearing itself. How can it work better? How can people be prepared to be a pro se litigant better? How can they understand what is being done better? Those issues is kind of one topic. The second one would be mediation, arbitration. Some states mandate, some states don't. Some states work mediation in the sense that we've got to figure out an equitable way of paying alimony, having custody of the kids and so on, and let's try to work it out. Some states actually add counseling, and I remember thinking I misspoke last time when I mentioned counseling. I have since discovered some states not only have mediation, but counseling. There are certain ways of relating that will cause harm and certain ways that can diffuse situations. I know that from being one of two alpha dogs in a marriage, that how we communicate can help considerably. So the issue of mediation, arbitration, and perhaps counseling. Do you remember the third point? No. That's right, you weren't here. Yeah. Okay, so there is a third one, and as people come and testify, I am suggesting to our court clerk, who is nebulous at the moment, that she make 3 folders and one for each kind of topic. That way, if somebody comes in and testifies early in the process and we don't get to that topic for a bit, not to worry, we'll find it. And here we are. Welcome, brave
We're here.
ones. I know, I can see that.
Made it. Got
We have
too
some
much blood.
we have some handouts.
I forgot my file in the car.
That's okay. These were put in this place. You can take your name tags, please, from down yonder.
Thank you. You're so much more organized than I.
You only say that because it's true. Yeah.
Oh, thank you.
Wow.
Thank you.
She's getting ready to go on vacation.
Oh, way to go. I'm jealous. Jealous.
She has that I'm going on vacation look about her, doesn't she?
In our office, or DHHS office, your name plate may be there. Up on.
But we will vouch for you.
In other words, you're willing to certify that I'm me?
Are you you?
Well, I can check my.
Only if you want us to.
Okay. Mark this well. Or Markel for short. Okay, good. You may be seated.
Okay. Sorry to interrupt you.
Oh, I was on a roll. I was good for about 2 hours. But
Cool beans.
yeah. Last time, Judge Michael Mace made a wonderful presentation. We have a document that outlines his testimony. And Attorney Grant, our committee researcher, and I came up with a few topics that might be good for initial reports. This big, fat, juicy one, Counselor, is one of those. And I sat in the back porch yesterday afternoon, last night, reading it. It's got lots of stuff. We find that some of the discussion in the initial 20 pages is very, very similar to the final report of the special committee that some of us were on last 2 years, which says to me, people are a constant, and maybe there are certain issues that continue to be problematic. We will find from other states possibilities. One for you, one for you, and one for everybody else. Yeah, come on up higher, friend. You may approach counsel. I love to say that.
Oh, good.
And these are the links to go to West Virginia, South Carolina, Rhode Island, New York, Delaware, South Carolina, and Kentucky. Notice they're red and they're blue. This is a wonderful sampling. NCSL researchers are working with me on this. I hold an NCSL fellowship in children and family issues, so I'm on the road with them 2 or 3 times a year, and I have a research team that loves to help. And so I would suggest we take a look. This subcommittee will not meet for 2 weeks. The whole committee meets next week. I would suggest that you spend some time looking at these different family court examples. One of the things that I have found in preliminary research is there's quite a spread of differences as to how a given state approaches the issue of family matters. Quite frankly, I think on some things we do it better than they do, and I'm willing to tell them that because I'm an alpha dog. And I think there's a few places where we might consider trying out some of the things they suggest. So we have a couple of other reports that there's only one copy of, and this is a good time to invest in paper products. I'm going to be reading these over in the next few days, and if they look like they have merit for the whole committee, I'll suggest we each get a copy. Okay?
Mr. Chairman?
Microphone, please.
Sorry. I'm so sorry. Thank you, Mr. Chairman. Those are the two, they were both attached to an email that was sent to us, I think, in the end, but one of them, I just got, it turned up blank. It wasn't a document in there.
Attorney Kristen Grant, our researcher, is the one that is taking point on any matters having to do with sending out documents and so on.
Thank you. I'll talk to her about it.
I mean, if we were to print out just what has been given to me from NCSL and from Judge Mace, the stack would be this high. And, you know, I have a good tolerance for reading, but it does peter out partway through that stack, I'm sure. So I want to skim stuff. And if it looks like it's good enough and important enough, I'll recommend we all get it. But I want to just spare us from getting bogged down in way too much. Well, with all of that in mind, the chair recognizes, let's see,
The chairman.
the chairman. But the chair recognizes, you see, the chair knows what they look like, and it whispers, thank you for that, recognizes Attorney Erin Cregan and guest. And Erin, if Attorney Cregan looks like somebody about to go on vacation, she is.
Can I come with you?
I might inspire jealousy. Sorry for the folks at home. Erin Cregan, General Counsel for the Judicial Branch. I'm going to Cambodia. You'll be in your full committee meeting, so hopefully you won't miss me too much, but I may come back with a tan. Maybe. I don't really tan, like a lot of people in New Hampshire don't really tan.
You're Irish, you speckle. I'm married to one, you know that.
So, but I know that if the subcommittee's meeting on the 15th, I believe Judge Christo will be available to meet with you.
She is going to be here? Good.
Yes. Yes. So you'll still have folks available. You'll still be able to continue your work. But I will be on vacation.
I want photos from Angkor Wat sent to us.
I can do that. And then I have with me here, what I should have done is memorized her bio because I excel predominantly as a hype woman, but I have Senior Administrator Heather Culp, who is our most senior administrator for the Circuit Court, very experienced. You know, I have not oversold that she can answer almost any question that you have on mediation. And I think she previously was a Harvard University researcher on court matters as well. She doesn't hype that, but as her hype woman, I have to hype that. So this is someone I think can be very helpful to you in learning more about the mediation program, which I know is one of your areas of interest. So she's kind enough to come today, and she has a little presentation just to give you some background, and then open to your questions.
Thank you. Attorney Culp, welcome.
Thank you so much, Chairman Pearson and members of the committee. I'm very happy to answer the questions that you have or find answers for them, specifically related to the New Hampshire Judicial Branch ADR programs. I do have a background in ADR program development around the country, doing consulting work with a not-for-profit organization who named Resolution Systems Institute, who did this work designing and implementing and assessing ADR programs in court systems and government agencies around the country prior to teaching in the ADR field and then coming to the judicial branch. So I do have some experience with what's happening in other state court systems and can share some information on that too, if that's helpful. I know the reason that you invited me to join you today was really about the ADR programs in New Hampshire. So that will be my focus, but happy to answer questions beyond that as well. So this legislature has been incredibly supportive of ADR programs in the court system for a long time. So the statute that created the Office of Mediation and Arbitration in the judicial branch was passed in 2007. So it's 490E, and that created not just a position, not just a program, but an office dedicated to advancing mediation and arbitration in the judicial branch. You also there articulated a number of purposes for those programs, and so we hew very closely to that list whenever we're designing a new program or assessing a current program to make sure that it's meeting those goals. I'm happy to talk you through those goals if that would be helpful at any point in time as well.
If I may interrupt, I thought of what that third topic is, and that is going to be the interplay between one of the litigants who is DV and the one who isn't, and how criminal court and tort can relate in terms of family. Different states do it differently, but just in case that informs what you do and before that thought falls out again.
Sure. I'll make a note to reference the provisions around domestic violence and mediation, as that might be helpful.
Because some people have asserted that in their family court trial, or DV never came up, even though it should have. And one judge didn't know what the other judge was doing. Now, I'm not saying what they should have done. I'm saying what the testimony was of enough people to give it plausible credibility that it sometimes doesn't happen.
Sure.
Okay?
Yeah,
Thank you.
Great. So the Office of Mediation and Arbitration is responsible for managing all ADR programs in the branch. So that's in Supreme, Superior, and Circuit. So in all three parts of the judicial branch. That constitutes over 12 statewide programs. And so anything from criminal settlement conferences in Superior Court to appellate mediation in Supreme Court to small claims mediation in Circuit Court. That does include the divorce parenting mediation program. It also includes other ADR programs within the family division. So as you well know, family division involves more than divorce parenting. It involves minor guardianship cases, domestic violence cases, juvenile cases, chins, abuse, neglect, termination of parental rights, et cetera, et cetera. So we do have mediation programs in minor guardianship cases, in termination of parental rights adoption cases, and that's statutory, those programs for voluntarily mediated adoptions. And we also have programs, ADR programs beyond mediation in the divorce and parenting realm. So we offer neutral case evaluation as well as mediation in divorce and parenting cases. So the scope of family division ADR is much broader than divorce and parenting. I'm happy to answer questions about that broad scope for this committee. I think what this committee has suggested you're most interested in is the divorce parenting realm. So I'm happy to focus my comments there unless you'd like me to talk about other programs in family division.
We can start there.
Okay, very good. So our divorce parenting mediation program is probably our largest program in terms of volume of ADR sessions. So I'm using 2023 statistics now, that's calendar year 2023, but we had approximately 3,400 mediation sessions in divorce and parenting cases in 2023. Now that's out of a total case volume of about 6,700 cases, give or take. I'm happy to get you those exact numbers. So when we're talking about divorce parenting cases too, it's helpful to acknowledge that for parenting cases, so that's cases involving non-married parents of minor children, and for cases where there's a divorce and minor children are involved or shared between the parties, we do send those cases to mediation as a matter of course. Now, 461A7, which regulates that part of the mediation program, is a may refer to mediation, and then it provides provisions for when it might not be wise to send parties to mediation. And then it does provide a prohibition, one prohibition for mediation. So while it is a may, we treat that as a strongly recommended and then offer people offer people other options for not participating in mediation if it's not wise for them to do so. The prohibition in 461A7 is around domestic violence. So to address your question, Chairman, the prohibition is around cases where there is a 173B case that is a domestic violence case. So you can imagine there are situations where there's not an active domestic violence case for whatever reason. Someone hasn't filed a case, or perhaps a final order, a final protective order wasn't granted, for instance. So that does allow the judge still to order them not to go to mediation, or order mediation with some additional protections around those cases as well. If there is an active 173B case, a protection order, then two things happen. If it's a civil protection order, then parties can only go to mediation if there's consent from both sides. That's consent from both sides. We can offer a number of different modifications to mediation to make that possible, including remote mediation. And it's truly only consent of both sides. So we don't have many people take that up, but we do have provisions if someone does want to mediate in light of their parenting case, and if there's a domestic violence order in place. For a criminal bail protective order, so if it's a criminal protective order, we do not permit those cases to go to mediation at this point in time. The reason being, it's not just the parties that have to consent. It would also have to be the prosecutor in that case that would have to consent. And so for us, the challenges of getting consent from all parties for a mediation to occur in those situations is the burden is too great for us to proceed in those matters. So we don't have those parties go to mediation. The vast majority of cases are offered and do go to mediation. They're often scheduled in the first instance from their first appearance session. So that first appearance session gives them kind of an informational session about what to expect in the divorce parenting process with minor children. So it outlines what documents they'll need to get to a final order. It outlines what options they have in terms of additional supports that the court system provides, and it outlines the process for what's next, including mediation. So often mediation is scheduled directly from that session. That session occurs with one of our case managers. So case managers are specialized staff in the court system who handle divorce parenting matters and meet directly with parties on those matters to provide them with information and, if needed, to help them complete paperwork. So a case manager can meet with both parties together if there's an agreement on what they'd like to do and they just need some assistance with paperwork. The case manager can hold a case manager conference and assist them in that way. Case manager can also help individual parties to complete documents. Once again, the case manager doesn't provide any legal advice to them, but helps them complete the paperwork, particularly with financial information, with figuring out what additional documents they may need to present to the judge. That case manager can be particularly helpful. So that case manager is also the person that holds this first appearance session, information session, and then we'll schedule mediation directly from there. Mediation can also occur in divorce cases where there are no minor children involved. Fewer people take that option, but that is an option in those cases. I think it's about 25% of parties in those cases do go to mediation. In the situation where minor children are involved, either parenting or divorce, we have a little over 50% of those cases that go to mediation. I will note that about 40% of cases in the divorce parenting realm don't ever go to a hearing and don't ever go to mediation. So either they complete documents and file complete documents with the court and we review and a judge would sign off on those orders, or they withdraw that case. So if you think about it in the context of total percentage of cases that move forward toward further process, a hearing or mediation, of the vast majority of cases do go to mediation when there are minor children involved. Even with the may in the statute, we take that very seriously as an option for parties to resolve as much as they want to in a session together. There is no mandatory agreement in mediation, so there is no requirement that parties come to an agreement in mediation. It's also an opportunity for parties to come to partial agreements if they'd like to. So for instance, if they'd like to agree to an alimony arrangement, but they haven't yet resolved child support and parenting plan, they're welcome to do that in mediation as well. All issues are on the table in mediation unless parties take off particular issues. So, and that's statutory by design, so that we're really able to resolve as much as possible and as much as the parties want to, as many issues in the case as possible in mediation. Really, it's a great way too for parties to receive that assistance completing documents. So the mediator will assist the parties in completing those documents at mediation as is appropriate. Once again, not providing legal advice, but helping parties jot down what their agreements are if they do come to agreements in that regard. The mediator is contracted with the court to provide this service. Mediators in the divorce and parenting context are certified by the executive branch. So the executive branch, OPLC, has a mediator certification, family mediator certification board that oversees all the certification requirements for family mediators in this state. So there are certainly folks who are certified as family mediators, but never seek a contract with the court. They simply provide those services privately. But if a family mediator would like to contract with the court to provide services for court-referred cases, they do need to get that certification from OPLC. Okay, very good. We also make available mediation for cases that reopen. Reopen is a bit of a technical term on our end, but for any case where a final order has been issued in the divorce and parenting case, so that is all issues have been resolved either by agreement or by a judge's order. If a party seeks to enforce those orders, amend those orders in some way, then we also offer mediation at that point in time. Once again, that's optional. They are certainly not required to go to mediation in those instances, but especially when there is maybe one or two issues, they find it helpful to return to, and we offer them the opportunity often to return to the same mediator they worked with if they liked that mediator as they worked with for their original case. So about 1/3 of the mediations that occur in the divorce parenting context are in reopened cases, and about 2/3 are in original cases. There is a particular statutory provision for mediation in issues where there is a contempt that has been filed, a request for a contempt finding that has been filed. We treat those as all other reopened cases. There is a timeline connected to that, and so we honor the timeline for that. But that is a particular statutory provision for those issues to be offered mediation. I'm happy to talk about any details that you may have questions about. I'm also happy to get you the 2024 numbers once we have those updated. We just had all of the data entered yesterday, so we should have some results for that in the next 6 weeks or so, and I'm happy to send those to you.
Got a couple of questions. Does the mediator make any recommendations to the judge?
No, the mediator does not speak with the judge. That's prohibited under our rules, and so the mediator would not be communicating with the judge. There's There's one exception to that, which is the mediator completes an ADR report, and that goes into the court file. So that's a document in the court case. Anyone could view that document. What that document does is really define what the conclusion of the mediation was. So they don't describe what happened in the mediation, but was the case settled? Was the case partially settled? Did the case not settle? Have the parties requested Y type of hearing, X type of hearing as the next set of the process?
In two places, at least in your handout, the term neutrals is used. Would you let us know what that is?
Yes, neutral is an overarching term for any person who provides ADR services. So that's inclusive of arbitrators, inclusive of neutral case evaluators, inclusive of facilitators for settlement conferences. So the ADR office oversees neutrals that provide these services. So it's more than just mediators. It includes folks who perform other types of ADR services in the courts.
You may have touched on this, but as you were spelling out various things that ADR does, do you have recommendations to organizations, people outside your ADR group?
Do we make recommendations to others, or do I have recommendations for other entities to look to?
Are there outsiders to whom you refer?
I see it. Does the court refer to outside
Yeah.
neutrals? So for some of our programs, we do not for divorce parenting or any of the family division programs. So all of the family division ADR programs, we utilize mediators or neutral case evaluators with whom we contract directly. So
They're in-house. Yeah.
correct,
Okay.
correct. Of course, folks are welcome to go to any mediator they'd like to, and that provision is in the statute 461A7 as well, that they're welcome to go to any provider, whether or not it's court referred. But if they would like to use our court contracted mediators, then we're happy to have them scheduled with those.
You spoke of initial appearance. Would that be an initial appearance before the judge?
First appearance is first appearance in court.
In
And-
court?
yes,
okay.
and so we do that. We do that in some locations remotely. So sometimes it's a phone call, sometimes it's a WebEx meeting with the case manager.
It's not the judge, it's the case manager.
Correct. Yes.
And then it says, then mediation, if desired, if allowed. How soon after?
Yes. So we try to schedule folks for mediation within 30 to 45 days after that first appearance session, and almost all of them we can get in within that time frame.
One of the things I'm pushing for in the next budget cycle is for more judges, for one thing, more general court people, not just judges. And it would be helpful to know delays. If a mediator isn't available for 30 or 45 days, is it because that's a cooling off period? Is it because they've got homework to do? Or is it because that's about as soon as we can do? Maybe if we had more mediators, it could be 20 days. Which would it be, do you think?
It's a great question. At this point in time, we have sufficient mediators to cover the sessions that we've made available to folks. In my experience, but I'm happy to look into this further, folks often need a bit of time to complete the paperwork in advance of mediation. So things like gathering their financials together, et cetera. So usually that first appearance session is fairly soon after they file. And so for some folks, it is a fairly new, especially if the filing was a surprise to one side, it's a fairly new experience. And so getting some paperwork together and working out scheduling, especially if parties have attorneys or even one attorney on one side. Sometimes you're working with the attorney's schedule, which can be complicating more complicated to work out, just with another added person who's also a professional who's in court fairly regularly over the course of a 30 to 45-day period.
But at this point, you're reasonably well stocked.
At this point in time, yes. I know that the Family Mediator Certification Board may have more to say about the availability of family mediators and interest in family mediation as a career option or as a supplement to someone's career. But at this point in time, we have sufficient mediators to cover our needs.
Representative DeSimone.
Thank you, Mr. Chairman. So just trying to get it straight in my mind what the process is. So you have your first appearance, then you see a mediator. Let's say that one party or the other is withholding information, financial information, and the other party says, hey, wait a minute, that party's withholding information. Is that when mediators then recommend, okay, can you bring that next time? Or does it go straight to a judge at that point?
Yeah, great question. So there are a couple different options for pathways. So one is the mediator can offer another session and say, okay, in 2 weeks, let's get back together. In the meantime, please exchange these documents that are required by the court rules. So that's an option. Parties can also choose to end mediation and proceed to a court hearing if they'd like to do so. So the requirement for a party is that they appear at the first mediation session. They're not required to speak. It's a voluntary process, and so they do need to appear. But if they would like to end the process at any point in time and return to the regular court track, they're welcome to do that. So the next step perhaps would be a temporary hearing with the judge to deal with those kind of threshold issues. Depending on where they are in the process, perhaps it would be a scheduling conference to schedule them for a trial at that point in time.
Follow up.
Thank you, Mr. Chair, and thank you again for that. So if mediation comes to an end because one or the other party is being adversarial, typically, I won't hold you to it, how long does it take for both parties to be able to get in front of the judge?
Great question. It depends a little bit on the location, and I'm happy to get you that information. Time between the end of a mediation session and a temporary hearing. If you have particular locations you'd like me to look into, I'm happy to look at that. Depends on the court calendar and availability.
I was thinking average.
It's difficult to speculate on that, so I appreciate you not holding me to it. But it could be, especially if it's a temporary hearing on a fairly urgent matter, especially if it's related to children or if there's an urgent property issue, we would try to get them in within that 45-day to 60-day window. But I'm happy to look into that and provide that further.
No,
Follow it.
thank you. You have enough work to do. I appreciate that. That was my thought process. But I just wanted a little validation that that's what the goal is.
Yes.
I understand there are outlying situations that can change that, but thank you very much. Don't go to any more trouble.
Thank you.
Following up on Representative DeSimone, if somebody is intentionally withholding relevant information from a mediation session, I've read in a few states the internal debate about granting mediators subpoena power. But if this is voluntary, subpoena power falls to the ground, because if the mediator says you shall, we know what that one party will say in response. But if it is an important thing, and mediation therefore breaks off, sooner or later the judge will know this, and if he or she deems this important, then subpoenas come in. Subpoenas has been this sort of strange creature wandering through the halls here for the last couple of years. So I just wanted to say subpoenas is not an issue here.
Correct. The mediators don't have any power to order anything. They're not called upon to testify. So what occurs in mediation remains in mediation. And so they're not even testifying in cases about what occurred in mediation.
Is the communication privileged?
So we have a few different provisions that protect that information.
500 series of the Rules of Evidence book. I didn't see it. I saw attorney-client, I saw medical person, I saw counselor, 505 is clergy penitent, and so on. I don't think I saw where that would be covered. Would that be a subset of something that I missed?
Yeah, so let me distinguish a couple different things. So mediation is confidential in the sense that what occurs in mediation shouldn't be shared out, but can't be shared outside of mediation. So that comes from a few different places. It comes from statute, 461A7.
Say that one again slowly.
Sorry, it comes from statute from 461A7. So that's
A alpha 7.
correct.
Okay, thank you.
461-A:7. So it's confidential based on that. It's also confidential based on the agreement that the parties sign together to participate. And so there's an agreement that they sign, that's a court-based agreement that they sign. So that's confidential, meaning not to be shared outside of the mediation. Mediators have privilege in the sense that they're not required to testify in court about what occurred in the mediation. So that's a little bit different than confidentiality. Their protections, so this is, once again, executive branch certification process, but RSA 328C provides some of those provisions for certified family mediators. So that's statutory as well. That's really managed by OPLC.
Therefore, one of the litigants could not call to testify the mediator.
They would be welcome to request that a mediator come testify. I know mediators have quashed those subpoenas in the past based on privilege.
Has it ever occurred that a mediator is compelled to come to testify by one of the litigants and the judge allows it, and then the mediator proceeds from that point in court?
I don't know of any instances in which that's occurred.
Okay.
It may have occurred, and I just am not aware of it.
Okay, thank you. Other questions? Counsel, other questions?
Very accurate and very comprehensive. I'm sorry, I'll put that on the record. I thank the attendees here for being concise, comprehensive, and accurate.
Thank you.
What else do we have?
Are there, sorry, I feel as though I might I don't think I'm in danger of hitting you with this, but I feel like I might. Are there other mediation or ADR, alternative dispute resolution programs you'd be interested to discuss more? For example, the neutral case evaluation program. It's not mediation, but it is something a lot of people find really useful in the divorce and parenting area.
Neutral case evaluation, so this is another subject.
It's another type of neutral. It's a non-mediator neutral.
Neutral but non-mediator. Okay.
Yes, so neutral case evaluation is also offered in the divorce and parenting case type. Neutral case evaluation is a bit different than mediation in a couple ways. One, we use retired judicial officers to provide this service. Two, the retired judicial officer that serves as the evaluator does that. They provide some evaluation. So they're facilitating conversation between the parties, trying to understand where the parties are stuck, and they often provide some kind of evaluation of the issue should the issue go to trial. So this is particularly helpful because they have trial experience and they have most recently been making those decisions. And so having a perspective about what may happen at trial, what is likely to happen at trial, what they might do if they were sitting on the case, is helpful to parties when they're stuck on particular issues. So this is offered to any party. Most often, it is parties who have counsel who take advantage of it. Unfortunately, we don't have a lot of availability for those sessions because it does require us to have a retired judge or retired judicial officer come and provide that service. And they are happily retired in many instances. And so the sessions that we have are few and far between, unfortunately, for the demand that we have for that service. Those sessions are 3 hours at a time. So most neutral case evaluators can hold 2 sessions per day. So 2 different cases per day. At the end, there can be a full agreement, there can be a partial agreement. It can be scheduled for trial after that session as well. So it's another ADR option that we have, not as many sessions as we have with mediators. It's also often used toward the end of the case when parties have worked through a number of issues. Mediation is required prior to going to neutral case evaluation. So as long as the parties have attempted mediation at some point in time in the case, they can proceed to neutral case evaluation toward the end of the case. So it's often used for much more discrete issues where folks are stuck toward the end of the case.
Yes.
I have a question.
Representative Nelson for the win.
Thank you, Mr. Chairman. And thanks for taking my question. I just wanted to be clear that the participants do understand going in that this is a retired judge.
Yes. So they similarly sign an agreement form that lays out the role of this neutral case evaluator, the fact that they are a retired judge, and also that they're not serving as a judge in this particular matter.
Representative DeSimone.
Thank you. Again, I just find that this is intriguing and so important for me to get this path straight in my mind. So I never going there. Thank you, God. However, I'm in mediation and we're at an impasse. We then can go to this particular judge and try to navigate through the impasse. And then if that doesn't work, that's when we would go to trial. The neutral judge would be after mediation,
Correct.
before trial.
Correct. Yes. There is usually some kind of hearing after mediation and prior to someone being referred to a neutral case evaluator. So often the judge on that case would see if there was any agreement made in mediation, see what additional issues are outstanding, perhaps sometimes even schedule a trial, or at least conduct a scheduling conference so that the issues are laid out if a trial does need to be scheduled, and then provide the option of going to neutral case evaluation. Yes, so there is often an interim hearing. Very infrequently would you go from mediation and then a few days later or a few weeks later have a neutral case evaluation.
Is our process very similarly used in other states?
We have a few things that are fairly unique to the ways that our ADR programs are run, and some that are fairly similar to the way ADR programs are run. One of the unique aspects of New Hampshire is that we provide this service to anyone, regardless of their socioeconomic status. That is not true in most other states. Most other states require all parties to pay for it themselves, or they waive a mediation requirement altogether for folks who can't afford it. So we do provide that service to anyone here. Neutral case evaluation is a fairly unique process to us as well. There are some other states that have some version of settlement conferences. Some of them call it family arbitration with a judicial officer. We uniquely use retired judicial officers. So it's not a sitting judge who does a rotation, though we have used that model in the past. But because we're using retired judges, there's some assurance that that judge is never going to sit on your case. We wouldn't have that anyway, even if we used active judges. But it ensures that we're able to utilize resources that are not being utilized by the court to hold hearings, but we're really utilizing their skills and abilities in helpful ways. Many other states do have family mediation and offer family mediation. Many other states offer some additional family services. They'll have a family services department that offers some additional services. You referenced that, Chairman Pearson. So we don't have as robust family services as many other states do, but we do our best with our resources, especially in the ADR realm. I think we have an exceptional ADR offering for divorce parenting cases in particular compared to other states.
I have not followed the progress of the bill, but if the bill raising the retirement age to 75 did pass and was signed into law, oh, good. Well, no, not good, but good for this, because if judges who love to do it are still doing it up to 75, just personal testimony, 75 gets tiring sometimes, and then you're not going to have as many do it.
Chairman Pearson, sorry if I misspoke. We utilize retired judges. So those could be judges that are over 70, or they could be judges who have chosen to retire before they turn 70.
Oh, I'm sure.
So those are folks who are not currently sitting on cases.
Understood.
Yeah, okay.
But those who are so eager to keep going might not have the time to do neutral case evaluation because they're still sitting actively and enjoying it. Whereas had the bill passed, they would be retired at 70, like it or not, and might say, pick me for this. So, okay, didn't think that part of it through when the bill came along. Counseling in, oh, we have until noon. Hold that thought. But I'm encouraged. Thank you. I've written mine down. The chair recognizes Representative Nelson.
Thank you, Mr. Chairman. I appreciate that. Just formulating in my brain some of the things that we hear in testimony, and what you're describing sounds to me like really a great process. Is this entire process mapped out for the parties in the sense that they're able to see like a visual flow chart or something? Because what I'm hearing might be a confusion in process where people are saying that they're seeing multiple judges, where in fact they might see this retired judge for this part and then another judge for another part. So how is this process communicated to the parties?
Yes, great question. We do have a first appearance map. So it is that flow chart for folks when they participate in first appearance. So that map does lay out a couple different options that they have at various decision points. And I appreciate your recommendation, or I'm taking it as a recommendation to really add who the person is that they might see at this mediation stage or at this neutral case evaluation stage. So I appreciate that, and we'll add that to the map.
See, we're working collaboratively already.
That's our goal.
That's us.
One step closer.
Somebody keep talking. I'm trying to get the live feed cranked back up again.
We do also have a first appearance video, so folks have the opportunity to see. It's about a 9.5-minute video that lays out the process for a divorce and parenting case. It uses that map actually as a visual to guide folks through it, and the video was created by judges. So you have a judge and a literally in a black robe standing and describing what the process looks like for folks. We also include on that map that they receive a list of all the documents that they need to complete prior to the conclusion of the case, so they can use it as a checklist for completing those documents.
Representative DeSimone.
Thank you, Mr. Chairman. So, let's see if I have this correct. Prior to the first mediation, the parties will receive a list somehow of the documents that they need to have prepared, the documents that they need to present, which would be outside of the documents supplied by the court, like parenting plan, things of that sort, which the court supplies the parenting plan, correct? Okay, so they receive all of that list. Now, a parent, for whatever reason, has difficulty filling out, let's say, the parenting plan. Is it ever the intention of the mediator to assist that party in filling out that or any other document?
Yes, so we have two different folks that can assist parties in completing those documents. So the case manager is a court staff person whose job it is to assist particularly self-represented litigants with completing those documents and learning more and educating them about the process. So an individual could make an appointment with the case manager to help complete those documents. In mediation, the mediator can also assist parties in completing those documents. The mediator would not meet individually with a party outside the context of a mediation to assist one party with completing those documents, because the mediator would need to assist both parties equally in that regard.
Follow up.
Thank you, Mr. Chairman. So what I'm getting at and why I'm asking these questions is I'm trying to formulate the amount of time that it takes for the first appearance case manager and mediators, well, not necessarily the mediators, but for everybody to get all that documentation together so that the mediation can actually be more productive. How many hours do you, or minutes, whatever, do you guess it would take for any party to fill out all that paperwork with the assistance of a case manager?
We schedule case manager conferences for 1 to 2 hours. So depending on what the party needs assistance with, sometimes that can be sufficient. We may schedule another one, for instance, or if the case manager has some extra time, they can stay a bit later and longer. Mediation we offer in 2 different sessions. Each session is 2 hours at a time. And so if the mediator is assisting the parties with completing those documents, if they haven't come in with those documents, sometimes the mediator will set aside time for each party to complete their financial affidavit, for instance, and then have them come together, and then they can start discussing how to complete a parenting plan or child support guidelines, things like that. If the mediator is assisting just with completing that joint parenting plan, perhaps a final decree, then the mediator would do that with the parties together during one or perhaps both of those sessions. So one of the reasons that we break it up into 2 sessions is so that they can understand at the end of the first session what more they need to complete whatever documents they need to complete, and they have a little bit of time in between those sessions to come back and to gather those documents and come back for a second session.
Question, please.
One more question. Representative DeSimone.
Thank you, Mr. Chairman. So I'm going to play devil's advocate for a second. Is it true that in any other aspect of the court, not family court, that there may be case managers and mediators as well that would be being used for 2 to 4 to 6 to 8 hours for one case?
We have very few dedicated case managers in other case types. So we have dedicated specialists. We have 2 dedicated housing specialists that can assist with landlord-tenant documents in that same way. And we have 3 dedicated IEA/IN case managers. So those are involuntary admissions or involuntary emergency admissions case managers who serve in that kind of case manager, assisting all parties as they need role. We don't have dedicated case managers throughout the state in any other case type besides divorce parenting cases.
Okay. So I'm trying to think about, and of course we have this bill, and the reason for this committee is that some people feel that the family court's not necessary. So I'm trying to decide, as we all are, what would happen if we didn't have a family court. So my thought process is that if you didn't have very many case managers and mediators, in thinking about the layout of a courthouse in and of itself, the amount of rooms available and so forth, if this 2 to 8 hour process were to be in regular district court, wouldn't that create a space crunch as well as a time crunch for parties to be able to settle their cases as quick as humanly possible? And I'm not even talking about the amount of judges it would. Wouldn't it elongate, because you're trying to get a room, you're trying to get a case manager, you're trying now to get mediators into a room and whatever? Isn't it going to just exacerbate the time element?
So this goes back a little bit to Chairman Pearson's question earlier about scheduling and what is prohibiting scheduling sooner than 45 days, for instance, for mediation. So currently our courthouses are both family division and district division courthouses. So we don't have any standalone district division or standalone family division courthouses. So we currently share that space. And so often mediations have to be scheduled on days where there is not a district division day because the conference rooms need to be used at the courthouse for family mediation, for instance. So the clerks of court are doing the lion's share of the work in figuring out locations and space and logistics of how to make sure that parties are able to access space to do mediation or do a case manager conference in the midst of also having landlord-tenant cases and criminal cases and other case types. Some of our courthouses also have probate divisions. And so it's not just family and district divisions that are sharing the space, it's also probate divisions. And so if you have for instance, a guardianship of incapacitated mediation on the same day that you have family mediation scheduled, now you're trying to determine best space for all the parties involved in those situations.
I think one thing I'm picking up on in your question, Representative DeSimone, is what's different with Superior Court. And one of the things that's different from the Circuit Court and the Superior Court is the Superior Court has juries. And so a lot of courthouse space and a lot of courthouse procedure and a lot of the utilization of different areas is about bringing in juries, impaneling juries, waiting rooms for juries. That is all space that couldn't be utilized for things like mediation and the things that the Circuit Court does, because there's a little bit of a conflict with needing that space to accommodate all those panels of juries and people that are coming in to be evaluated for juries. That doesn't happen in Circuit Court, so the space can be used for things like mediation and arbitration.
So if we were to abolish family court, how would the scheduling and any mediation or case managers, how would all of that change?
I think we would probably need some direction about from the legislature what we do with our current circuit court locations. Is the intention to continue to utilize those, but now those are Superior Court locations, or is the intention to consolidate in the 11 geographic places where there's a Superior Court? Because if it's the latter, there will definitely be space issues, and there will also be accessibility issues, because right now it's much easier for a lot of people to get to their local circuit court, and this isn't true for everyone, but there are 32 locations, there are only 11 for Superior Court, so you may be driving a farther way. So I think it would depend what the legislature directed us to do in terms of, are all our circuit court locations now Superior Court locations, or are we intended to contract in some way? And we would just need to get that direction on what we're supposed to do.
And since we got the live feedback, I just want to point out to any Superior Court judges who happen to be tuning in, Representative DeSimone was only giving a hypothetical.
Absolutely hypothetical.
right.
And again, there are 11.
We have 10 counties, so we have 10 Superior Courts, except that Hillsborough is large enough that we need to have a north and south in Hillsborough.
And
then
that's the circuit,
that is the Superior Court.
Superior. And how many circuit?
32 circuit court locations.
Yes, it was definitely a hypothetical. It scares me.
Not happening on my watch, by the way. Got a couple of questions. This may have been touched on. I may have been finishing up writing the previous thought. Of the 2023 divorce cases not involving children, what percentage of them did not go to trial because mediation solved it?
If you'll forgive me, I'll look at my computer to make sure I'm accurate in those stats, or I'm happy to send you those
Given the
stats
choice
separately.
of accurate information from a computer and a wild stab in the dark, yes, please.
Okay. Very good. I'm not shopping for shoes, I promise. As I mentioned before, about 25% of those cases, divorce cases where minor children are not involved, go to mediation. So it's a much smaller percentage of those overall cases than cases with minor children involved. So we're looking at a pool of about 25% of all of those cases.
That I've
filed.
got. I may have misspoken.
Very good. No.
Of the divorce, no kids in mediation, what percentage goes to trial? And obviously the rest of it didn't.
Yes, so I will share stats related to your question and then tangentially related to your question. So once again, a large percentage of divorce cases without children neither go to a hearing nor go to mediation. So they're resolved in some other way or withdrawn or dismissed prior to getting to any hearing. So that was about 68%. 68% in 2023 of cases without children that had some kind of decree we call it decreed, that final order, did not attempt mediation and did not go to a hearing. 68%.
68 didn't go to mediation and didn't go to a hearing.
Correct.
Let me try another question. Of the divorced no kids that did go to mediation, so we have a smaller pool here, what percentage of those had to go to the court and what percent didn't?
Yes, so I'll speak to that whole pie of cases that went to mediation. So of those, 40% settled in mediation and had no additional hearing after their mediation. 30% did not fully settle in mediation and had a hearing, a subsequent hearing. That could mean that they partially settled in mediation and went to a hearing. So that's inclusive of cases that are partially settled. 14% did not fully settle in mediation, but also had no subsequent hearing. So it could be that mediation contributed to that settlement. It could be that after mediation, they decided to withdraw the case. We don't know specifically, and I don't want to guess at causation, but 14% are in that category of not settling, not fully settling at mediation, but also not going to a hearing. And then 12% settled in mediation, but did have an additional hearing. So why would that be? Sometimes there is an unclear provision in an agreement in mediation, so the judge will request parties come in. Sometimes there's an unenforceable provision that might be agreed to in mediation that the judge can't sign off on. Sometimes there could be insufficient information in mediation, for instance, and not full disclosure, so the judge would bring the parties back. Sometimes people have cold feet after they complete an agreement and request a subsequent hearing. So once again, I can't guess as to all 12% of those, but those are some reasons that there may be a hearing after a settlement. And then there's 4% other. So not sure what would have occurred in those instances, but happy to look into it if you need.
Okay. Different question, and back to a comment I made earlier. I noticed in some states, mediation is part of it, but so is counseling. Given that mediation solves problems between people who aren't changing, they're just doing differently, counseling may help individuals make some changes that would be beneficial going forward, whichever way they decide to go forward. Has this been considered recently in family court, a counseling branch?
We've not considered that, as far as I know, in the New Hampshire judicial branch. I do know some other states do have that, as you referenced. Wisconsin particularly comes to mind. They have a family division or family services division that's attached to their family courts. So that contains things like counseling, like parenting coordination, like assessors, like GALs, services that have been put in the judicial branch for the purpose of being a place where a judge might refer cases, but still within the judicial branch.
I may have missed a word. Unfortunately, it's the most important word. I either heard or did not hear the word New Hampshire has or has not recently considered doing this.
As far as I know, we have not considered, but there could be conversations that I haven't been privy to.
It's a big thing, as I personally know, but also in doing the reading in those states where it is recommended that they have to be approved as probably their equivalent of OLSC, and so on, but they make the case for it, and it may be a little side issue for me to look at.
And one thing that sometimes impacts what we have in New Hampshire and what's common is what there's federal funding available for. You might see certain things being very common in certain states because it is a clear option. You can get Title IV funding for it. Some things states only have where that state is willing to completely 100% fund it. So you might see that counseling, for example, could be rarer because it doesn't neatly fit into something you can get federal Title IV funding for. So the state has to make that commitment that they're going to fund it without federal dollars. And that can be a wrinkle that sometimes impacts how common certain types of options are.
Make your wish list. There's no urgency. Any other questions before we see if she can go on to another topic?
Well, I know you're interested in divorce and parenting, but are there other family cases? I think Heather mentioned at the beginning, we have different kinds of neutrals that work on different types of cases. Is that your kind of primary focus, the divorce and parenting area? Or are there other cases that you'd maybe be interested to hear about what some of the options are?
If I remember correctly, most of the testimony that went to the special committee was in whole or part around divorce custody issues. I'm not sure what else family court does.
So family division covers a number of case types: minor guardianships, domestic violence, juvenile, chins, and all the cases related to abuse and neglect. So that, for us, that's multiple different case types, but they're all under the umbrella of abuse and neglect. We also handle child support matters under the umbrella of divorce parenting cases, but we do have cases where child support is the only matter before the court, and they're involved with the Bureau of Child Support Services in that regard.
We had a bill 553 that attempted to give definitions under abuse and neglect. And it was one of those, to my view, really good, but no cigar. And which is why we have tabled it in the House. I have a photo of the vote. It was 300 and something to 1 to table it. It's the closest I've ever come, other than consent, to 0, because it was too good to say no, but it wasn't good enough to say yes. And it's out of this committee. And we're going to be spending quite a bit of time in the next several months to get it so that it can go on consent next time. So matters of abuse and neglect are very much going to be before us for the next several months until bill filing in November. Some of us just couldn't say yes, but we sure didn't want to say no. So we said table, and that means we can come back in the fall with more legislation, more perfect.
We're happy to help with that in any way that we can. If you have technical questions, of course, the policy determinations are always up to the legislature, but if there's anything we can be helpful with, let us know.
And you know how I like to work. This is going to be fun. Representative DeSimone.
Thank you. I'm glad you brought that up, Mr. Chairman. In light of what has happened with the amount of children who have been murdered by their parents, that's the reason 553 came forward. In House Bill 553, if I don't know if you have read it at all, that pertains particularly to definitions of child endangerment. So I would really appreciate getting feedback from all of you to help us create a bill that is palatable for all to protect the children so that we do not have another Harmony Montgomery case. That we do not have another case where the gentleman was just arrested last week after he hurt that baby and then looked it up online to find out what the injuries meant and so forth and so on. That's why I believe that it is important to have these definitions. So if you could help us with that, that would be, I think, groundbreaking.
You both as attorneys know, and I as a third year 1L know, you'll get people who will come before you and they're sincere. Whether they're correct or not is another issue, but they're genuinely sincere that the courts move in and took their kids away way too soon, or DCYF, or somebody took them away. And the next person you talk to is just as sincere that the people across the street, they didn't take them away, and they should have, because look what happened. And fallible human beings have to live in that gray area. We can do the best we can, and we want to, but as you know, those two extremes exist, and you live it, and we have to legislate it. And so a collaborative effort would be very welcome. And some of us can put names to both of those categories. Representative DeSimone.
I'd like you to recognize Representative Nelson.
I do recognize her.
Thank you. Thank you, Mr. Chairman. Thank you, Madam
Recognize
Vice
you,
Chair.
and I
Thank you.
recognize you.
Thank you. Thank you so much. I do have and this is like another process organizational question I have in my mind. Complex cases where there is both civil and criminal child abuse / endangerment within the same family. How is that managed between the two court systems?
So a couple different things might be true in those cases. There may be an active abuse and neglect case in circuit court and perhaps a criminal case in superior court. There could also be a criminal case in circuit court and an abuse and neglect case in circuit court. And so it may depend a little bit on where the courts are, purely in the sense that if you're in a small court location, particularly with one judge, it may be one judge that's handling the abuse and neglect case and the criminal case. But if it's in two different courts, or if that court has more than one judge allocated to it, it could be two different judges handling those cases. So there may not be direct knowledge of of the facts of each of those cases. So too, but part of a party bringing forward information relevant for that case may be bringing forward relevant information from other cases that they have. And so some of it is relying on the parties to bring forward information for those cases. So.
Follow up.
Thank you. I know it's really complicated. I just, just in prior cases, part of the issue in certain cases in the past is that a judge just simply did not have the proper evidence or the whole story of the entirety of the abuse that was happening. They only had one piece of it. So thank you. It's, I'm trying to put my head around that and figure out, how we can do better.
And I think sometimes you do see the executive branch agencies coordinate with each other. So they may say, the prosecution may say, we need to go first for a couple of reasons. One may be that getting admissions brings in the person's Fifth Amendment rights in the civil proceeding, and that the standard is higher in criminal. So there's often an interest in the executive branch in putting criminal proceedings earlier, because then if that's resolved, then you meet the civil standard. So it can be easier sometimes, but it really depends on the case type. But you can have that across all kinds of case types, that you could have criminal proceedings that have some nucleus of facts that affect a civil proceeding of some kind. And I think a lot of times the executive branch tries to sequence criminal to civil, but it depends, because if you have an emergency with the children that you need to address in court, you may need to have an emergency hearing on that, even while the criminal case is unfolding over a longer period of time. So it depends a little on the case type and the facts of the case, but because you have DHHS and prosecutors who are both from the executive branch, they can sometimes be working on what they think is the right sequencing of the different relief that they're seeking as parties.
We have heard more than a little testimony that there were two different cases going on and neither judge knew it. I think I'm hearing a partial answer on there are ways they can know this, even allowing for screening out things. It sounds like it doesn't always happen. And how could it happen better? That both courts know?
I think the biggest challenge is where there's a big geographic space. And this is something that came up, I think, also last year in the bail debate a little bit, that someone would be on bail for something that they did on a Friday in Portsmouth, and then they drive to see their family in Nashua or Lebanon or somewhere totally different, and it's not the same county attorney. It's not the same police force. There's really very little overlap of the people involved, and then they commit another crime on a Saturday, and no one knew that there was a bail order, from less than 24 hours earlier. So I think you can see that in different case types. There are certain things that make that more likely, like a large geographic space, no overlap in the executive branch agencies that are dealing with it, no overlap in the court staff that's dealing with it, and a small amount of time also makes that more likely that something could not be known.
Thinking very much as a liberal arts person, and also knowing the problems with that. A domestic violence case has now been scheduled, an arrest has taken place, there's going to be a criminal typed into a database that family court judges cross-reference with names to see if there's a match. I mean, the security on this would have to be very strong, of course, but is that not possible?
This is another context, but in last year, the legislature did fund a bail data platform to deal with those gaps. I will say, I think that I'm not sure where it is in the competitive bidding process, but it was and is hundreds of thousands of dollars to bridge some of those gaps. Not a surprise to any of our legislators that most state government computer systems are low functioning. The goal is price for a lot of these things, to get a functional, workable website system that people can file in or get information about cases in at a competitive price. So the companies that create those services for state government, their objective is always to undercut in price their competition. And there's not a lot of companies that do it in the first instance. So there's not really high functionality, high usefulness. It's not great for generating data. It's not great for generating cross references. So in order for us to create something that would fill that gap for bail, we had to go to a bidding process that was substantial. It's adding a big functionality to our system that it doesn't currently have. I haven't evaluated where if we wanted to do that more for family offerings, like what that option would be. But I think our family offerings are larger. We have a larger family docket than we have a criminal docket. So it could potentially be a more significant challenge technologically.
Yes, and my apologies. My my colleague is incredibly accurate. We do have more criminal cases in the circuit court than we have family division cases. So just wanted to clarify, the majority of our cases in the family division are divorce parenting cases, though all other case types put together are more than the divorce parenting cases. So happy to provide you the stats on that as well. They're also available readily on our website, so you can see the number of cases there. Just the one other piece around the issue of judges looking things up, there may be some ethical standards related to judges doing independent research about cases before them that may prohibit some practices that would otherwise seem helpful or wise, and so just want that consideration to be available as well.
And yet there are limits to those limits, because we have learned in small courts, a judge may hear both. And one clearly informs the other. I mean, I can compartmentalize, but not that much.
Certainly. And I'm not a judge, so can't speak directly to that, but know that our judges have spoken previously before this committee about having to do that separation in their head and making that separation for themselves. I think one other distinction is cases that are confidential versus cases that are non-confidential. Abuse neglect cases are confidential, whereas a domestic violence case, for instance, is not confidential. And so that may have some impact as well on what information can be shared. For instance, between a circuit court abuse and neglect case and a superior court criminal case, there may not be the ability to directly share confidential information with superior court, absent some other court provision that would allow for that.
So it may not be advisable for an intentional consolidation of those cases. I realize I'm leading the witness here.
I think that would be your call as the legislature to make some of those determinations.
That should the legislature see that an intentionality of consolidating criminal domestic violence and family children's custody things would be in the best interest of the innocent victims or potential victims, is something that we could go forward with, but it would not be anything the judiciary would initiate.
Well, I believe, for instance, in some of the DCYF regulating statutes, there are some of those provisions about information sharing. So that is something the legislature has done in the past.
And most of our rules on confidentiality, they're direction from the legislature. You tell us in statute what you want confidential and when it can be shared and with whom. So if you think that that's not working for some reason, you're getting feedback from someone who would have done something with that information. These are changes the legislature can make and does make from time to time to be more clear about who can receive information and when.
Coincidentally, I also chair the DHHS Oversight Committee, which of course has DCYF as one of its components. So that's a phone call to some friends. See what they think. Representative Markell.
Thank you, Mr. Chairman. Regarding consolidation of civil and criminal cases, or particularly if you're dealing with the same set of facts, do you think there might be some constitutional questions involved with that?
There will certainly be different issues. So for example, for a criminal case, you have a speedy trial, right? That has to be done. That often means that our criminal docket bumps other things on the docket, because if we do not meet those constitutional guarantees, the case is entirely dismissed and justice is not done. People may have an entitlement to be heard by a jury constitutionally, which for other case types they won't, but that can be a challenge to add a non-jury and a jury case type. They may have a presumption that of innocence that has to be overcome by reasonable doubt versus preponderance or a lower standard. So you could have challenges in how you would separate out some of those different constitutional guarantees. And you have constitutional guarantees not only in criminal cases. They're different, though. When we're talking about maintaining your relationship as a parent with your child, there's a constitutional dimension to that, but it's not identical to what you experience as a criminal defendant defending yourself in a criminal case. Maintaining that relationship in the way that's guaranteed legally is a different guarantee, and it's given effect in a different way.
Thank you. Yes?
There's also a right to counsel in both
Yeah.
abuse and neglect cases and in criminal cases, for instance, but those counsel are different counsel in
Yes.
almost all circumstances.
Yep.
With different training, different expertise. One is constitutional, one is statutory.
Yeah.
So they come from, so theoretically the legislature could adjust one, whereas the other can't be adjusted because it's constitutional. So it is and I don't think you would get a lot of public defenders that necessarily want to cross train in family law or vice versa. So you would run into some practical challenges.
And yet,
Thank you.
in a small court, it does happen.
And we have different models for managing court process. For instance, family treatment court is a different model for handling an abuse and neglect case that does include sometimes some of the criminal case aspects. It doesn't resolve the criminal cases themselves, but they take into account sort of the whole family, whole world approach for those children. And so that could include criminal charges against a parent, for instance, where that would be part of the conversation at the table with the team of people handling that particular case.
So it is possible that there could be a domestic violence case pending against one of the parents in Superior Court, and there would be some kinds of family court cases where those two could be consolidated, but not so much others because of these clashes that have been raised?
I think it depends. What I would want to help a legislator with when they're talking about consolidation is what are they wanting to achieve, and what statutory change would would achieve that purpose, because you could theoretically call them both in the same case number, but that might not cause any efficiency, if they have a constitutional right that something has to be done right away and then something's done later. Does having the same case number advance a specific legislative policy goal? I think I would want to understand what the objective is, and then you would fashion a solution that would try to achieve that, because I could see that consolidation in name may not give you the result that you want, but you could achieve a policy result, and it's technically not the same case number, for example. So I think it depends what the objective is, how you would solve it legislatively.
That's what I have been doing, working backwards, at least in my mind, is those situations where one of the members has a criminal DV case pending, and that would or perhaps should speak to how the arrangements are made in family court for those two adults and one or more children. That may be important.
And normally the person who is the person who is under the order of protection, that they're the person being protected, will raise that. They'll
Okay.
say, I have an order. He's not allowed to, or she's not allowed to be near me. So when we do a drop off with parenting, we need to do it around my order. That they'll typically raise that because that is their own concern, that they want to make sure that their order of protection is being honored. So it's most of our process relies on the fact that people are going to raise the things that benefit them. They're going to bring that to the attention of the court, say, I need to be protected from this person, and I need you to make sure that you're fashioning orders around this order. So it's a little unusual for someone to fail to mention that, if that's something that they've gone and sought from the court and they have an order. They would ordinarily remember to tell us that. Not that it would ever be good to not have that information, but ordinarily the person will make us aware of that.
See, this is why I'm still a 1L. When those people said what they did, this wasn't brought up in court that so-and-so. Well, why didn't you? Is what I should have said.
I mean, it is an adversarial system. I hate to say, you think of like totally other countries, like you think of France and Germany, where they have an inquisitorial system where a court person goes out and gets all the information. We don't have that system. We have a system where people bring the information that benefits their side to the court, and then the court makes a determination between those two sides. We don't have a big wing of people like they sometimes do in other countries, that all they do is, they don't have police force, they have investigating magistrates that go and investigate, or things like that for criminal systems. We're relying on the parties to tell us what's important, and then we'll give them that decision on how to resolve their competing interests. So it's a little unusual for someone to fail to mention something that is really important to them, that they want us to consider and bring into the case.
So in your professional opinion, how would you address the occasions of hypothetical people testifying who might say they never made the connection? How would you address that? I mean, now in retrospect, I'm thinking I should have raised that question. Why didn't you bring it up? But what would the possible other, how can I give some credibility, or can't I give credibility to that as an objection?
Oh, I'm not suggesting that it doesn't happen. I think it probably does, especially big geographic difference, totally different agencies, short period of time. That can happen. Without a technological solution like the one we're pursuing in bail, it's a little hard for me to say that there is an obvious solution. That's the way that it was resolved to a somewhat similar question. But if you have specific stories that you're thinking of, here's how it harmed the case, maybe that's something I can collect from you and kind of think a little bit about how would we solve those problems? What were we missing? How would we have gotten it? And what difference would it have made in the case? That might be something I'd have to look at a few instances where it happened to see what the options would be to address it.
Representative Markell.
Thank you, Mr. Chairman. Yes, some of the issues I think you're raising some good points, particularly about criminal orders of protection, bail, and parenting plans. So some of the things I've seen in my practice are where a defendant who is facing misdemeanor DV charges has criminal bail orders against him or her, and at the same time they have a DV case pending, okay, in the family division, and the DV case comes with a parenting plan, but they can't, and you end up in a catch-22 because the parenting plan gives them some rights, okay, for visitation under certain circumstances, such as meet at a certain place. But if these other circuit courts don't amend their bail orders, the defendant never really gets a chance to see their child because you're in that catch-22. Just an observation.
Yeah, I think what I would see is someone would go back and ask for the
Yeah.
criminal bail order to be modified.
Yeah,
But you could have the problem where someone doesn't realize that's an option,
Yeah.
potentially.
yeah.
Representative DeSimone.
Thank you. So we're talking about the technology that is being created for the bail issue. Is that technology only going to be dedicated for that particular issue, or can it be extended to other areas of court which would be less costly?
That's a great question. I tend to think criminal may be a little bit less costly because criminal must be public typically. So you're not dealing with any special technological protections of information that it needs to be confidential. It can't be hacked. It can't be accessed by the wrong party because criminal trials are required to be open except under very, very, very limited circumstances. So that may be an easier type of information to treat. I don't think we've looked at, I mean, I think it is a good question. You start building some infrastructure. Is there an ability to leverage that infrastructure for other purposes? You know, I can tell you that the bids we're looking into are to solve the problem that we've been instructed to solve by the legislature. So certainly in a not very easy budget year, we were not necessarily thinking that we would expand beyond where we were asked to be because we do not want to volunteer state resources to something that we were not explicitly asked to do necessarily. But I think that is a good question. You start building infrastructure. Does that lower your costs to build more infrastructure? I think the answer is potentially that it does.
Thank you. So it seems to me that when you're building the infrastructure, and being that I am preschool technologically,
Me too.
it seems to me that when you're building this, it could be included in the writing of the infrastructure to give an option to put particular instances in a privacy file so that the information isn't given out. So I'm just thinking that should be, although it would be at a cost, it should be minuscule at best if we did it in the beginnings of the build, rather than wait and say, oh, now we have to build new stuff. I just think it would be easier. Does that make sense to anybody else but me? Thank you.
Let me, I know that is relatively early days. Let me get more information about that from someone who knows a lot more about technology than I do, and see if there is good information that I can share with you on that.
Thank you. I appreciate that.
Okay. For the subcommittee, the whole committee meets next Tuesday, starting at 10 o'clock. Some easy-looking Senate bills come over to us in the morning, and a great big one comes in the afternoon. I sent you all emails yesterday. Please read the bills ahead of time. For Republicans, there will be a caucus, 7 o'clock next Monday night. Thank you so much for coming. And do you have a card?
I don't, but I'm happy to have Attorney Cregan provide my information, you're welcome to reach
Or
out to me
write
directly.
something on the back of a 20 or something, if you wanted to, because I have a card for you. Thank you so much for coming, Attorney Culp. Attorney Cregan, when do you leave?
I leave on Friday and I'm gone for 2 weeks.
Good girl.
I don't think I've ever taken a 2-week vacation before. I'm not sure what happens when you go on vacation for 2 full weeks.
Didn't you just go to Florida a few months ago?
I did, but I was tentatively gone for a few days, and then you never really stop receiving work emails if you're gone for only a few days. So I don't know what happens if you're actually gone for more than a week.
Oh, it's fun.
And life goes on.
Yes.
Yeah, we'll really miss you.
And it's all here when you get back. Yeah.
It will definitely
And then
all
some.
be here. But you'll have lots of Senate bills to work on, and you won't even have an opportunity to miss me before I'll be back and see you.
We will finish them all up next week, God willing. They say all I've got is all we'll get.
Wow,
So we're gonna do it.
there's some government efficiency for you.
Try. As do you.
And wow, with a minute to spare, this ends the meeting of April 1st. No kidding. 2025 for the Subcommittee on Family Court from the Children and Family Law Committee of the House of Representatives of the State of New Hampshire.
Thank you.